All right, so we are now out of the executive branch, thank God, because it's a long and involved content. But this is even worse, so don't worry about it. This is the federal court system. This is the judicial branch out of Article 3 of the Constitution. So out of all three branches, legislative, executive, and finally we get to judicial. Today we're basically going to run through the federal court system and make some mild comparisons to state courts, but really we're concerned with the national or the federal court. So the top-level courts in the nation with federal laws. And we're going to go through the federal court structure later on in this lecture. All right, so take a look at this. This is a good place to pause, maybe write down the information. This is the checks and balances relationship put into a graph form. You'll see this again later on in a future lecture, as well as probably at the end of this one again as well. There we go. Got that bar out of the way. All right, so the federal court system. Courts use the law, constitution, statutory, common law, all that fun stuff, case law, to settle civil disputes and to decide the guilt of innocence of people who are up for trial. And those are two different issues. So when we see the term guilt or innocence, or really you're never going to see the term innocence, you'll see guilty and not guilty. That's a criminal context only. Civil disputes, you deal with something called liability, in some cases with contract breach. So you're going to see different language for different kind of court situations. Article 3 established that there was a national Supreme Court and gave Congress the authority to make all lower federal courts. The only court system, the only court that's actually mentioned explicitly in the Constitution is a Supreme Court. That's it. So all the lower courts are made by federal statute, and they can be made, they can be unmade, they can be removed. And that kind of brings up a slight issue considering judges have lifetime tenure. What happens if they have a court one day with a judge there for a lifetime, and then they get rid of that court? Does that judge stay there? Do they go away? And I think the usual solution is they kind of shuffle them around and give them like a magistrate position, something similar. Basically to prevent this whole back alleyway to fire a justice when they don't really technically have the authority to do so. So just know that you can have lower courts removed or added to the system. You can also have the number of Supreme Court justices change over time. They have changed quite a bit. I think they topped out at 11, maybe, although I can't quite remember. And the lowest they've ever had is 7, I want to say. So that number does change around over time. All right, these are the words that are actually on the Supreme Court's marble building. And now that marble building is important for two reasons historically. One is where the Supreme Court does their job, so that's obviously important. But the words are equal justice under the law. This tends to come out of that 14th Amendment ideal of equal treatment, post-Civil War, end of slavery, making sure that recently freed slaves are treated equal as people under the law, and applying basic rights to all the state laws as well. And we'll talk more about that later on the semester, as well as it'll be covered pretty heavily in U.S. history. And this is the actual Supreme Court building. Now, this building was not always there, obviously. It had to be built at some point. But William Howard Taft, who was president at one point in U.S. history, did not want to be president. He hated being president. He didn't like it. This is the guy who's famous for being stuck in his bathtub because he was very obese. He's also famous for being the only president to serve as both president and then later serve as Chief Justice of the Supreme Court. So that was what he really wanted to do. Justice Taft wanted to be Justice Taft. He didn't want to be President Taft. That was just kind of something he did. However, one benefit to Taft having been president first was he was able to use all those political connections he drew from being president to basically make more concrete the role of the Supreme Court in the country. Prior to Taft, Supreme Court decisions would have a great deal of variance. There'd be dissenting opinions. There'd be 3 or 4 dissents in the minority opinion. There'd be all these various changes around. Justices used to ride circuits, so you'd have a Supreme Court justice who would have to go to California to deal with issues. After Taft, they stayed in one spot. The Supreme Court doesn't go anywhere anymore. They don't ride the circuit. Now there are circuit courts that are basically the Court of Appeals. They're out there, but they have sitting judges there as well. Before this, the Supreme Court was it was a bad gig to really have because you were basically on trains, in carriages, just riding across the country, basically dealing with all these various case laws that made it up to the state courts, to the appellate level. And there's a close-up of equal justice under the law over there. We'll skip through that. If you want to pause and look at it and wonder, feel free, but I'm going to keep going. All right, each state also has its own courts and laws and systems. So there's federal laws up top and there's state laws at the bottom. They each have their own separate court system. So there is a court system for the state of North Carolina. There's also federal courts within North Carolina to deal with federal or national action and national laws inside North Carolina. So you have 2 different systems. Most cases, a large majority of cases, involve state laws. Whenever you see a major, like the famous one that's been recent, O.J. Simpson, that's not a federal court, that's a state court. That was a state court trial. Most trials happen in state court. Most criminal law happens in state court. It's relatively rare for criminal law to make it to federal court simply because it requires, one, a lot of time and money on the part of federal marshals and U.S. attorneys and the FBI and everybody else. It's also less law to work with. So there's a lot more state laws and state ordinances than there are federal laws and guidelines on the criminal side of things. There's still drug laws, still anti-homicide laws, all those things, but usually the state courts are left to them. All right, so here's the court system. First thing you need to know about federal court systems is the word jurisdiction. All it means is authority. It's a court's authority to hear and decide a case. That's it. That's all jurisdiction means, and there are different kinds of jurisdiction based on what court we're talking about. So jurisdiction, just know this, the basic definition, a court's authority to hear and decide a case. All right. In federal courts, so all national level courts, Supreme Court, the Court of Appeals, U.S. District Courts, all those guys, they have 8 cases where they have jurisdiction. First, cases involving the U.S. Constitution. The U.S. Constitution is the ultimate federal law, so obviously, or the ultimate national law, so obviously it would go to a national court. Violations of federal laws, kidnapping, counterfeiting, those things, so statutes made by the Congress and then signed by the President, any violation of those kind of laws, they are allowed to go to federal court. Disagreements between state governments. So if you have Virginia and North Carolina suing over something, let's say it's a state boundary where like the boundary line is drawn. If it's in a North Carolina court, guess what? North Carolina courts can be biased towards North Carolina. So you don't want to have a neutral arbiter, a neutral party, in this case the federal courts, to hear that decision. So that's why you go straight to the federal courts for those issues. Lawsuits between citizens of different state. We call this diversity jurisdiction. And this one's kind of two-part. One, you have to have a diverse issue going on, so you have a Virginia citizen and a North Carolina citizen suing over something. You also have to have a money requirement. Early on, it was like $20. It was not a big money requirement. Now it's $75,000. But basically, it's just to make sure there's not bias in the state courts, or at least it gives the parties in disagreement the option to remove a case from state court where there's diversity to a federal court that may be more neutral. One thing you need to know: federal courts are much more expensive. So if you're talking about a $2,000 contract dispute, you don't want to go to federal court. The filing fees will kill you before you ever make any money back. So you want to stay in the state courts. Sometimes, though, you have tens and tens of thousands of dollars, hundreds, millions of dollars in dispute. Then you go to federal court to make sure that the court system's, at least in theory, going to be neutral. Number 5, lawsuits involving the federal government. If you sue the national government, guess what? The national government wants to have their home field advantage, and they get to have it. Cases involving foreign governments and treaties. So a treaty is a national law. Remember we talked about how treaties almost have the force of the Constitution themselves? Well, guess what? You have to go to the federal court to deal with that kind of issue. Same thing with any foreign government. So you can't sue Iraq in court in North Carolina. You can't. They're a foreign entity. You go straight to the national government. That's considered almost like foreign policy. They don't want a state to suddenly just grab property owned by Saudi Arabia because there was a lawsuit. Cases based on maritime law. Maritime law is just law on the open ocean. Those are a lot of issues with ports of entry, that kind of stuff. And in theory, a state could handle this, but the idea is that you want maritime law to be uniform across all the coasts and all the waters. The easiest way to do that is to actually have maritime law handled by the federal courts. It's also in the Constitution that maritime law is given jurisdiction is given to the federal government. And then finally, cases involving U.S. diplomats. If you're dealing with someone who is an ambassador for the U.S., it's going to go straight to federal court. It could be anything. It could be a crime that they're accused of. It could be a contract dispute, or it could be anything that involves their capacity as a U.S. diplomat. Then they get to go to federal court. Now, that being said, if a U.S. diplomat who's over here gets a speeding ticket, they don't go to federal court. That's not they're not doing anything in their capacity as a U.S. diplomat. So that would not be in case. But if like the U.S. diplomat did something like corruption charges, that kind of stuff, like maybe they stole money or embezzled money or took a bribe, then that goes straight to federal court just because it involves the U.S. diplomat. Now, federal courts have exclusive jurisdiction in most of these areas. Not all of them, but basically they're the ones that can only hear it. There are certain exceptions to that. because like diversity jurisdiction, that's really at the option of the parties whether or not they want to stay in the state courts or go to federal court. So there are some exceptions, but for the most part, it's okay to think about these as places where only the federal courts are allowed to talk about it. Now, in a few cases, states have concurrent jurisdiction with federal courts. Just know that. Oh, sorry, I'll go back. Just know that, like, for example, if there is a murder in North Carolina that someone has to do with drugs, let's say drugs going up and down I-95, and there's a murder as a result, basically killing off some competition, that could technically be under a federal RICO statute for organized crime, drug trafficking, so that could be at the federal level. It can also be at the state level for murder. So that's really at the option of the feds whether they want to prosecute first or not. They pretty much get first crack. So another example would be bank robbery. Bank robbery is a federal crime. The FBI handles that kind of stuff. It's also a state crime. And ever since 9/11, the FBI has been more concerned with national security issues than they are with bank robbery. So if you were to talk in 1950, bank robbery was a big thing that the FBI had to deal with. Post 9/11, they're concerned with terrorism, so they leave the bank robbery charges up to the states to deal with most of the time, unless there's some big major issue with like a bank robbery cartel or major corruption with wire fraud, that kind of stuff. But for the most part, the feds have the option to say, yeah, we're not going to take that case because we got other better stuff to do, and then the states are kind of left holding the bag and they got to deal with it. All right. So let's talk about organization. We talked most about jurisdiction in those last few slides. Now let's talk about how these courts are actually organized from the top down. And that chart down there, you'll see it again. It's very important. I would know it, and I'll tell you which parts kind of to ignore for my course. All right, first there's U.S. district courts. These are the trial level courts. This is where you basically would start a lawsuit or a criminal trial. This is the trial level where you're going to see a jury. This is where that's going to happen. There's 94 district courts in the entire United States. Now, original jurisdiction is the ability for a court to hear a case for the first time. District courts are courts of original jurisdiction. Typically, any given case is going to start at the district court level. That's all federal cases. There are there's a select few cases that can bypass district court and just go straight to the Supremes, but they are exceedingly rare. So for the most part, if you see the term who has original jurisdiction in a blankety-blank case, for the most part, it's going to be the district court level. We will talk about the exceptions to that later on. District courts are where you hear witness testimony, where you see juries, where verdicts are attained. So guilty, not guilty. Liable, not liable. That is determined at the district court level. We also sometimes call this the decider of fact court, because they're actually deciding what the facts are and what they mean and how to interpret them in reaching a verdict. Later on, your courts of appeals, your Supreme Courts, their job is to deal with questions of law, whether the law was applied correctly, whether a right was violated. That's for the courts to decide. Juries, judges sitting as finders of fact, their job is to literally decide the facts equal this. The facts are X, Y, and Z. And they'll hear the entire alphabet, A through Z, of varying stories, facts, and testimony. And it's up to the jury to decide facts X, Y, and Z are correct. And it's basically their goal is to determine what the real facts are and come to a decision based on a unanimous verdict. These district courts hear both civil disputes between two parties and criminal cases where laws are broken. So you will sometimes see, like most time people always make the association with Law and Order. Law and Order, they deal with criminal cases. District court, but however, that is the state level. That's the state of New York versus blah, blah, blah. This would be the U.S. versus blah, blah, blah. So federal district courts, you're going to hear U.S. versus the defendant's name, and that's it. In civil cases, sometimes it'll be the plaintiff will be, let's say it's Principal Ward versus U.S. That would be a civil dispute where Mr. Ward would be the plaintiff. Every state has at least one U.S. district court. North Carolina has 3, and some states have 1. Think back to that whole it's the same reason that there are representatives based on population. Wyoming has 1 congressman. They have 1 district court. It's just because there's not many people. On to the U.S. Court of Appeals. They have what is known as appellate jurisdiction. Shocking. They're an appeals court, so they get appellate jurisdiction. It's the authority to review a case from a lower court. So the lower court here, in this case, would be the district court. They come up with a verdict of guilty. Well, there was a bunch of stuff that happened in the court, like what evidence got in and out, and let's say I'm the defense attorney and my client lost, but I say they let in a bunch of evidence they shouldn't have. They broke the law by doing that. I would appeal it to the Court of Appeals, and they would decide the question of law, like was the trial fair? Was the evidence that was allowed in legal? Was the jury non-biased? All these whatever I appeal, whatever the basis of my appeal on, would then be determined by the appellate court. Their sole purpose is to review decisions made by the lower court. Typically, they're not going to decide, okay, were they guilty or not guilty. That happens, but it's exceedingly rare. Most of the time, they're going to be dealing with findings of law. They're going to decide, was the law followed? Every now and then, you will hear a case where an appellate court decided an issue of fact, but that is very rare and almost never happens. Finders of fact are juries and sometimes judges at the district court level. They are never the appellate court for the most part. A panel of judges makes up every court of appeals. It's either 3 or more judges, and hopefully you always have an odd number because you never want to have a stalemate. And right now, as of the making of this PowerPoint presentation, we currently have 8 positions on the Supreme Court, which is basically the highest level appellate court. So they can tie. And the problem with that is if they tie at the Supreme Court, then the decision of the lower court automatically stands. It basically survives. So you have an issue right now. You want an odd number of justices on all these courts. That way there's never ties, or at least you hope there's never ties. And once again, appeals courts don't decide guilt, innocence, liability, or non-liability. They don't decide who should win the lawsuit. Their job is to decide who or what was actually done correctly or incorrectly as far as legality. Were due process rights followed? Was the Fourth Amendment violated and they let the evidence in anyway? Did the police torture the guy to get a confession? Is that illegal? That's what they decide. They decide whether or not the evidence was good and that procedure was followed. That's their issue. They deal with questions of law, not with questions of fact. They're not going to deal with how many pounds of marijuana did they find in the warehouse. They're going to deal with, was the marijuana found in the warehouse found legally? That's what they're worried about. There are 13 U.S. courts of appeals, and it has nothing to do with 13 colonies. It's just that's the number that's come up, and we can add more, and obviously we can add more, take away based on the Congress's view of how many courts there should be. Congress could add another court tomorrow. They could take away another court tomorrow, as long as the law was passed and signed by the president. Each one covers a particular geographic area, and we refer to this as a circuit. So if you see the term circuit court on a test question, know that just means the appeals court. They're the same thing. It's an old-timey word used for back when the Supreme Court justices used to do what's called riding the circuit, which was where they get on carriages, trains, whatever, and travel the country and decide disputes. Whereas now they're all in D.C. deciding the major cases. And this is a quick map of all the circuits. So if you ever wonder where your circuit is, if you are in my class, you are in the 4th Circuit. So that's North Carolina, South Carolina, Virginia, and West Virginia, and Maryland. You have some other courts out there that are a little different. So you have the 9th Circuit is considered a very, very liberal court. They're way out here. And there is some talk right now about basically trying to make California, Oregon, and Washington the 9th Circuit, and giving some of these other states a different circuit, because the culture out in California and the laws of California are way different than in Montana. Montana is a huge pro-gun rights state. California, not so much. So you have some major differences of opinion at the appellate level. All these different courts of appeals that are in here, they're all very different. And if you have most of your justices on their California appeals court for the 9th Circuit, if they're out of California, they're not going to know about what they're doing over here in Montana as far as law and precedent. They'd have to bring in experts to find that information out, in theory. So there's actually some talk currently about them splitting this circuit up a little bit, because it is a large geographic area with some very different views politically, legality, like jurisprudence, all that fun stuff is very different when you go from California, way over here, all the way to Montana or down in Arizona, where the culture, where the political climate, where the legal climate is all just very, very different. And the 9th Circuit, again, also includes Alaska and Hawaii. Alaska is a very conservative state. Hawaii is very liberal. California is very liberal. It's a huge geographic area for just one appellate court to have control over. All right. U.S. Courts of Appeal continued. Appeal court rules on whether a trial was conducted fairly. So I've said this like 5-6 times, so please don't mess this up. The appellate court does not decide facts. They decide if law was followed appropriately. That's it. you will have questions that relate on the test to what appellate courts do. They have appellate jurisdiction. They decide issues of law. They do not decide issues of facts. Were the person's rights protected? Was the trial fair? That's what they deal with. They do not deal with, again, was it a pound of marijuana or 8 ounces of marijuana? They don't deal with that. They deal with, was the marijuana seized legally? Was the wiretap done lawfully? Were rights violated? All that. They deal with those issues, constitutional issues. Judges on these kind of panels have 3 choices, and this is from the Supreme Court and any other appellate court. So all the circuit courts of appeals. At the state level, it's the same rule. If you have a state court of appeals, they have these same 3 options. First, they can uphold the original decision. That's fairly common. So let's say the appellate goes through and they believe the conclusion of the district court was appropriate. Boom, that's enough. They upheld it. That's all there is to it. They can reverse the decision. This one is rare. It is rare for a court to look at a case and say, okay, not only were they wrong, they were so wrong that we're reversing the decision. So it would be like if O.J. Simpson was found not guilty and then it was appealed and they said, you know what, they were so wrong, now we're going to find O.J. guilty. They don't do that. They want that left up to the trier of fact. In that case, it would have been a jury. And then the final one, which is the most common option after upholding the decision, is remand. This is when they send the case back to the lower courts to do a do-over. So it's kind of awkward when you think about it, because what happens is the district court judge screwed up, and that's the only way to say it. They messed up. They messed up how they applied the law, and now the appellate court is saying, you messed up. We're remanding the case back down for you to not mess up this time. So do it all over again. And this is bad for 2 reasons. One, the judge looks bad. The judges don't like it. Second, it's expensive. They got to run the whole trial again. Usually by this point, the trial is already over. They've done jury selection. They went through the entire process, all that fun and expensive stuff, and they got to redo it. One judge writes an opinion to the court. This is a detailed explanation behind the legal thinking in the ruling. So basically, they're going to say, we come to X decision, whether it's uphold, reverse, or remand. They list out the law, followed by the facts, and followed by applying those facts to the law and the conclusion they come to. This is where you see all the precedent come out, the common law stuff that we talked about earlier in the semester. This is where you see all the citations for prior cases. All this stuff comes out in the opinion. Now, the big reason why this is important is because all these opinions, and usually there's usually one majority opinion and one dissenting opinion typically, if there is any dissent at all. They will have to follow precedent, and this new opinion that comes out will itself become new precedent. So if a case just like the one that they decide comes out, they'll look at this opinion again that the court just made, and they'll say this is the precedent we're following, just to keep the continuity and the stability in our legal system there. It's based on the whole idea of common law. Federal court officers. Federal judges. These are guys appointed by the president and then confirmed by the Senate. So these are the ones that serve for life. They never leave the bench, and they basically, unless they go senile, commit a major crime, or die, or resign, they stay there. That's pretty much it. They serve for life. They can't be removed unless they're impeached. There are more than 550 federal judges, and judges have been impeached, although I don't believe a Supreme Court justice has ever been impeached. Each district court has at least 2. So there's 2 judges. That because you would hate it if like one day a judge died and there's only 1 judge on that entire district court. Well, guess what? No new business can be handled until they appoint a new one. And those appointment processes can sometimes be very, very long and drawn out. Each appeals court has from 6 to 27 judges. So 27 would be like the Ninth Circuit, which is a huge geographic area serving a huge population. So you're going to have a lot of judges on the appeals courts. Magistrate judges. These guys aren't really district court judges. What they do is they listen to evidence and decide if a case should even go to trial. This would be almost like a grand jury hearing at the lower court level for the states. Is there enough actual evidence to go forward? So it's like basically the prosecution, in this case the U.S. attorney, goes up and says, hey, we have this, and this. Let us go forward in trial. And the magistrate judge will say, okay, I believe there's enough to go forward. And they'll basically set bail and off the races they go. And then at that point, they'll go to the district court and be in front of a jury and have to go through that entire process, which we'll go through in much more detail later on the semester. All right, so U.S. attorneys are prosecutors. So if you ever heard the phrase district attorney, that's the state-level prosecutor. Here is the U.S. attorney. That's the federal level prosecutors. And these guys take on a very hands-on role in the investigation. These guys talk to FBI agents just like a district attorney today would talk to a police officer. They're basically the ones that are prosecuting the case. The only major difference between a DA at the state level and a U.S. attorney. A U.S. attorney is going to prosecute crimes, but they're also going to represent the U.S. government sometimes in a civil case involving the U.S. government. So if someone commits a crime against the U.S., a U.S. attorney is going to represent our interest or the U.S. interest in prosecuting that case and trying to put that person in prison. On the other side of things, if there's a civil suit, so if they sue the U.S. government, a U.S. attorney is also going to defend the U.S. there. At the state level, a district attorney who prosecutes people is never going to defend the state or the county in a lawsuit. That's the DOJ's problem. That's the county attorney's office problem. They're different entities. So a prosecutor at the state level will not defend civil lawsuits against the state. A prosecutor at the national level will defend civil cases involving the government. Federal marshal. These are the guys that arrest and transport prisoners. They protect jurors. They keep order in the courtroom. They have this weird combo. They're like a police force. They're the sheriff's office. They're the bailiffs. They're the process servers. They do everything. If you've ever seen the movie U.S. Marshals or The Fugitive with Tommy Lee Jones, he's a U.S. Marshal. He's like tracking down a prisoner who escaped, and he's got to get him back in the courtroom. All that stuff. So that's their job. Oh, also the movie True Grit. The main character in True Grit is also a U.S. Marshal. All right, so this is a good chart to have written down. So if you don't have it, go ahead and write this down. The one area for at least my course, if my students are watching this, don't worry about this. Know it's there, but I'm not going to test you on the Court of International Trade, Court of Claims, or Court of Military Appeals. Just know this is the process. If you want to get the Supreme Court, you got to follow this route. U.S. District Court, the Court of Appeals, to the U.S. Supremes. Now, the state courts also can make it to the U.S. Supreme Court. They start at the local trial courts, like our county courts. Then they go to the state appeals court, and then you go to the Supreme Court of the state. So we have the North Carolina Supreme Court, and then from there we go off to the Supreme Court or the U.S. Court of Appeals, depending on where you are. But each one has a path. You can get from the federal court to the Supreme Court. You can also get from the state courts up to the Supreme Court. Same information. If you want to pause it here and write it down, if this is a more available way for you to understand what you're looking at, feel free to copy it down. And that's it, guys. There's not much more to this. We're going to talk more about the process of the legal process in the judicial branch a little later, the actual arrest, arraignment, bail being set, all that fun stuff in order. We'll talk about that in a couple more units, so don't worry about that right now. We'll talk about the case law in the next 2 weeks after this next test we take. So don't focus too much on things like, well, what happens if this happens? What happens if they break into my house and take my stuff and then arrest me? Is that allowed? That's later. We're going to talk about that after this checks and balances test you're going to have in probably the next 4 or 5 days.